It's news time. Information is power. The current. The news headline. Ipob shops for new lawyer as Nnamdi Kanu enters crucial stage. The news in full. As the trial of the leader of indigenous people of Biafra, Nnamdi Kanu, enters a crucial stage, the umbrella body is seeking to recruit a top legal luminary to replace the current legal team that has been representing the breakaway agitator. Although Ipob has not discarded its current legal team, made up of many lawyers, some are rendering free services based on their belief in the cause that Nnamdi Kanu is leading. Ipob, however, wants the legal team to be spearheaded by a lawyer with high pedigree, generally known and highly respected within the Nigerian judiciary. A top source who is close to the Ipob organization said on Sunday that the current legal team is perceived to be populated by activists who are best suited to work with legal luminary of not below the rank of a senior advocate of Nigeria, SAN, popularly referred to as learned Sikh in Nigeria legal parlance. The source, who pleaded anonymity because he was not authorized to speak for the organization, said Ipob is looking for a highly placed attorney of a SAN status who is well versed in the Nigerian legal system and commands respect in the cycle. The envisaged SAN, when engaged, is expected to reorganize Nnamdi Kanu's legal team, mobilize qualified and like-minded lawyers to work as coordinated legal team to secure victory over his terrorism and treason felony charges slammed on him by the Nigerian government. As you can see, these are very weighty and serious legal issues that require a versatile legal representation and not mere activists who many just be more interested in drawing publicity stunts at the expense of the client. And we do not want anything that can affect our cause, the source said. Vanguard learned last night that one of the top lawyers being seriously considered by the Ipob leadership to champion the cause of Nnamdi Kanu is a highly respected lawyer, Ipob, who has a PhD in law and has been recording outstanding victories for his clients in most of the cases handled by him. It was, however, learned that Dr. Ipob was not likely going to accept any offer considering the huge implication it might have on his career as a leading international legal practitioner. It was not also clear, as at least night, if Ipob had even approached Ipob with any offer to represent his leader as the case against Kanu comes up early next year. As to explain the rationale for the hiring of a foreign lawyer from the US to represent Kanu in Nigeria, the source expressed reservations over the attempt to bring in a foreign legal practitioner to appear in a Nigerian court, pointing out that it might not work out at the end of the day. The issue of a US lawyer appearing for our clients in Nigeria may not work 100% in our favor, but it can at least draw international attention to our case, the top official said. It will be recalled that on October 18, 2021, the federal government had filed an amended 7-count charge against the Ipob leader, bordering on terrorism and treasonable felony. Count 1 of the charge reads that you, Nnamdi Kanu, male, adult of Araoku Ibeku Maya North, local government area of Abia State, being the leader of Ipob on diverse dates in 2014 and 15 in London, United Kingdom, did broadcast on Radio Biafra, monitored in Enugu and other areas within the jurisdiction of this honorable court, preparations made by you and others, now at large for states in the southeast and south-south, and other communities in Kogi and Benue states, to secede from the Federal Republic of Nigeria with a view to constituting same into the Republic of Biafra, and you thereby committed an offence punishable under Section 41, subsection C of the Criminal Code Act, Laws of the Federation of Nigeria, 2004. Count 2 says that he referred to President Muhammadu Buhari, the Commander-in-Chief and the President of the country, as a pedophile, a terrorist, an idiot, an embodiment of evil, knowing same to be false, and thereby committed an offence contrary to Section 375 of the Criminal Code Act, Laws of Federation of Nigeria. And that the third count charge was that between March and April 2015, he imported and kept in Obuluzizo, Iyala, local government area of Anambra State, a radio transmitter known as Tram 50L, concealed in a container of used household, which he declared as used household items and therefore committed a crime contrary to Section 47, subsection 2 of the Criminal Code Act, Cap C45 Laws of Federation of Nigeria 2004. And the count 4 charge says that Kanu had between 2018 and 2021 in Radio Biafra monitored in Enugu professed to be a member of Ipob and a proscribed, which happens to be a proscribed organization in Nigeria, and thereby committed an offense punishable under Section 16, Terrorism Prevention Amendment Act 2013, and so many more. And these, out of many, had caused the Nigerian Police Force, the Department of State Services, and other security agencies barring and blocking access to the premises of the courtrooms of Abia State High Court or any other court when it is in session. Adding down the order, Justice Benson Anya said that security agencies has no right to prevent people from accessing the court, while there must not be any arrest in the premises and vicinity of the court except as ordered by a court or competent jurisdiction. He gave the order following the court proceedings on Friday in the case of Nnamdi Kanu for the Federal Republic of Nigeria and 7 others. The leader of the proscribed indigenous people of Biafra, Ipob, is in the Abia State High Court seeking a leave to enforce his fundamental rights with the federal government. Attorney General of the Federation, AGF, and Minister of Justice and DSS, among others, listed as defendants. The police and other security agencies had formed the habit of restricting movement along Ikot Ekpene Road, Umaya, and other adjoining roads, as well as barring people from entering the court whenever Kanu case comes up for hearing. But Justice Anya faulted the excessive enforcement of the security, saying that barricading and impeding access to court is an anomaly in a democratic setting and could only be effected by security agencies if the court, the head of the court, so requests in writing. It is hereby declared unlawful to restrict citizens and members of the public access to the courtroom and court premises during the working hours of the court. The judiciary is a democratic institution with a mandate to protect the rights of the person or persons who approach the court to ventilate their grievances. It is unlawful to militarize it or cause the court to perform its functions under the force of arms, Anya declared. In addition, the court ordered that the federal government and all parties concerned must protect the sanctity of the judiciary, the freedom and constitutional rights of the people, and which there is a new phase being awaited for January 19, 2022, the next case of Nnamdi Kanu. Thanks for listening.